Well, given that it's 1 o'clock, I might get things started. Can everyone who's on the screen at least give me an indication visually that they can hear me? Thank you. Terrific. I'm Michelle Painter, one of the silks on the 9th floor Selborne Chambers, and I'm chairing this 1 hour CPD this afternoon. I don't profess to have any expertise whatsoever in the subject matter, so I'll be listening with as much interest as all of the rest of you, I expect. Well, we've got 3 speakers today. First of all, I'm just going to introduce all of the speakers, give you a brief idea what they're speaking about, and then I'll come back to the first one and we'll just get going in a seamless way. And I hope there will be some time for questions at the end of the hour rather than interrupting in between. But if there's something terribly pressing, try to use the notes function and I'll get to it as efficiently as I can. Our first speaker is Phil Lonergan. Phil came to the bar in 2016. He mainly works in commercial litigation. Before he came to the bar, Phil worked in finance for over 20 years, where he was involved right at the very beginning of the evolution of program and electronic trading in equities across Europe and Asia. And this, of course, gives him a unique perspective when we start looking in our field about how AI will or might disrupt the legal profession in the years to come. Phil's going to talk about generally disruption of that's posed by AI to legal services as we currently understand and receive them. And he's also going to talk a little bit about how we can expect the law to evolve with the AI process. Our second speaker is Sam Adair. Sam has been at the bar since about 2009 and he joined our floor a few years ago. We're very pleased to have him. Before he came to the bar, he was a solicitor working in the insurance practice group of a national law firm. He has a general commercial practice with a focus on building and construction work and on professional indemnity cases. Sam is going to talk about some of the, or attempt to identify some of the implications of using AI from the standpoint of our professional judgment and the exercise of it. And he will do a better job, I hope, than I could about giving some definition to that term. He'll also have a go at talking to us about how the concept of professional judgment in the context of AI can feature in lawyers' ethical duties and how it informs case management, and a brief mention of some of the regulatory responses to AI which have emerged in the Australian marketplace to date. Our final speaker is Josh Sukkar. Josh was called to the bar earlier this year. He accepts, as we expect of baby barristers, he accepts briefs in all areas of the law. He has a focus on insurance, professional indemnity, common law and commercial disputes. And before he joined us on 9 Selborne, Josh was a senior associate at a national litigation firm. Josh will be talking about his own personal experience with ChatGPT and the risks associated with its use, and will give us some useful and helpful observations about the use of ChatGPT in the legal market and what it means for the billable hour. So let me welcome you all. We really do appreciate you joining us for these sessions. They're important for us, and it's really nice to see our solicitors and others popping up on the screen. So welcome, everyone. And over to you, Phil.
Cool. Thank you, Michelle. Hopefully I'm going to speak for about 15 minutes. It's always a lot.
You're speaking, Phil, you're on mute.
Oh, I'm on mute?
No, we can hear you, Phil. I'll go around to Michelle.
Okay, you can still hear me? Yes, so 15 minutes is always a lot with me, but I'll do my best. So Goldman Sachs had their technology and media conference last week, and the takeaway, at least according to Yahoo Finance, was that AI was going to crush jobs. It's hardly a great headline for lawyers, but that's what they said. Goldman's chief technology officer came out and said that generative AI is going to be a profound disruptor to the finance world. And he also said that he expects that to go across all industries. News Corp's CEO, Robert Thompson, also presented at the conference, which I thought was quite interesting. His comments was that he expected AI to be a tsunami of job losses, or to create a tsunami of job losses. But then, and he referenced,
understand.
He expected that, well, he said that historically big digital.
Yeah, no problem. No problem at all. All righty. Okay, see ya.
Can I just ask, if you're not talking, if you just go on mute, it would help us. Anyway, he was saying that, big digital had caused on the newsroom floor in the United States 57% of job losses over the last 10 odd years, from 71,000 down to 31,000 jobs. Now, that's all quite doom and gloom, if you ask me. But nonetheless, certainly in the surveys that I've seen that have been presented, I think Deloitte did one a few weeks ago, a lot of people are very worried about jobs and the effect of AI on their jobs. And that's completely understandable. No doubt, and this is something that Robert Thompson picked up on. He said that no doubt AI will replace functions or jobs where they are easily replicatable or iterative in the way that they're done. So, a mechanization, or a replacement of rudimentary process, tedious process, back office type process, data crunching, all those sort of things. I mean, they're undoubtedly the sort of areas that, at least in terms of, if you think of jobs in part of a pyramid where you've got at the top, the high intellectual property part, and then as you move further down, you have a lot of process-oriented jobs. No doubt AI will, take a chunk out of those process-oriented jobs, and do so, I think, reasonably quickly. The real argument, and this is part of what I'll talk about in a little bit, is around the apex of that pyramid. How much of the real value add process can be replaced by generative AI models? Put it a different way, can AI replace human intelligence, or does it just merely augment it? I think for a large part of our value economy, service-based industries, which Australia is obviously a significant player in, augmentation of human intelligence is what we'll see for certainly the foreseeable future. And look, maybe one day it gets to the point where parts of the human intelligence or spectrum of human intelligence is replaced by AI. But I think we're a fair way yet from that. Anyway, Michelle referenced I was in finance for a long time. I think finance, at least in terms of the automation of the decision-making process, is probably 20 years ahead of law. Now, that's not disparaging or a disparaging comment in relation to law. What it is a comment about is that law deals largely with unstructured data. Finance, like in equities, it was a massive amount of data, a compilation of tick data, bid offer spreads, volumes traded at certain prices, and an analysis around trading patterns and all sorts of interesting stuff, gaming theory and the like, that started to get layered into our algorithms. But at the heart of it, it's a three-step process, I think, and I think that applies as much to finance or to law as it did to finance. And those three steps are really: 1, data collection; 2, data analysis; and 3, decision making. Now, it's easy, certainly a lot easier these days to collect data. Certainly in the finance world, it's tick data, right? So it wasn't that hard. But these days, in terms of the legal industry, collection of data is a collection of information, really. the advantage we have now vis-a-vis, say, 10 years ago or even 20 years ago, is so much of what we seek to collect is in an electronic format of some description. And even where it's not in, let's call it a rich electronic format, we have now, off-the-shelf solutions like, OCR recognition or optical character recognition. That's, Google Docs has it, Adobe has it with Adobe Pro, etc. So it is reasonably rudimentary now to collect data in a way that it can be interrogated meaningfully. That is a big change over the last, let's call it 5 to 10 years in the legal industry. Data analysis is then the next step in that process. Well, once you've got the data, analyzing it becomes a lot easier if you can, if you have the data in a way that it can be interrogated. There's a plethora of off-the-shelf products now that allow for, reasonably, in some cases, sophisticated interrogation of data to look for, let's call it patterns or code words or combination of factors that allows us in things like e-discovery to, with huge terabytes of data, actually interrogate them in a meaningful way without having some poor sod sit there for weeks on end reading through emails. Then, and I think in terms of the AI spectrum, it has a lot of benefit around that data analysis, because ultimately what AI or generative AI does is learn from patterns, and where you have significant amounts of data and replicatable process, which largely data analysis is, then machine learning, I think, is very adept at adjustment and recalibration, such that you can get meaningful result around interrogation of data through using generative AI models. Where it gets a little bit more interesting is around the decision-making process, because as lawyers, ultimately that's our job. We get a lot of data. We analyze certainly terabytes of data every year, although we wouldn't want to count sometimes how much data we actually analyze. But ultimately, certainly in the litigation space, we end up having to make decisions, whether it's this cause of action or that cause of action, or whether to sue or not. And I think this is where the augmentation versus replacement of human intelligence argument really is going to be at the forefront of in the legal sphere for the next sort of 5+ years, because we have to make the decisions. We're the ones that have the practicing certificates. We're the ones that have the obligations to the court. So ultimately, we're the ones that have to make the decision around how to litigate, what to litigate, and the the machinations of of different permutations within that spectrum. Undoubtedly, generative AI will be, I think, very helpful in analyzing the data for us, putting data into formats that make it much easier for us to view, to make decisions. And I think that you'll end up in situations where generative AI, it will be making a lot of suggestions or pertinent suggestions around what decisions to make. But I think ultimately, and for reasons I think Sam and Josh will touch on, the generative AI process is far from being infallible. What Robert Thompson, the CEO of News Corp said, which I think is right, is AI is very good of making or doing permutations around pre-existing content. Now, where you have pre-existing content and it can iteratively move here, there, and around it, but I think the legal space, yes, we have precedent, yes, we have pre-existing content, yes, we have permutations and cases arguably have different spins or permutations on precedents, but I don't think that the spectrum of the permutations that AI, at least presently, has capabilities for would allow for the replication of legal decision making. Moving then on to the second part of what I'm talking about, the evolution of law. Undoubtedly, it's going to evolve. Undoubtedly, it's going to change. Undoubtedly, it's replicatable processes are going to be replicated by AI. There's a Silicon Valley company called Harvey who does legal AI away from, let's call it, the public domain of ChatGPT and the like. Companies like Allens and Overy and PwC on the record as saying that they're using Harvey. What Harvey have come out and said, it's on their website, is that AI is not a chatbot that complements workflow in the legal space. Rather, they're saying that it's a platform that legal workflow will be built on or is built on. And I think that's right. The present, probably most of our experiences around the AI world is we've logged in, we've got an account with OpenAI's ChatGPT. We go on, we ask it a few questions, we get a few answers, some of them good, some of them bad. But we view it as a sort of another tool that we go and use on the side. I think that's right for a lot of us. I think that a lot of the accounting firms, large accounting firms, larger law firms are actually far more advanced in that space than using ChatGPT, i.e. Harvey, where they're integrating it into their entire workflow processes. And when you've got that and you're comfortable around the protection of your data, i.e. that the AI, the generative AI, is not learning from your queries, and also it's not exposing your content to the rest of the world, then people will feel a lot more comfortable around the integration of the generative AI into their day-to-day workflow and decision-making processes and analysis. Now, Microsoft have come out recently, I think a few months ago now, with their product called Office 365 Copilot. And if you can go on the web and you can have a look, they've got some demos around what Copilot's going to do. But it, in effect, is exactly about that. They're promising, take their promises for what they're worth, that their generative AI models will not learn from their subscribers, and that their subscribers' content will remain confidential and within the bounds of the subscribers' universe. So, that could be 1,000 people working for big law, or it could be 2 barristers working together, sharing an office account. But the interesting thing about it, and certainly when you go on and look at it, is that it embeds itself, generative AI embeds itself within your entire office environment. When I say office, I mean Windows Office. So you can expose all of your files, etc., to it. You can ask it questions that it will go through all your emails, go through all your documents, your PDFs. It will even go through transcripts of your Teams calls. It will go through basically anything that you've got to go and create content for you based on what you've given it or what it's available to understand context from. Now that's going to be extremely powerful, and but it's more powerful the more content you've got. And I think this is where certainly I think the larger law firms have got a comparative advantage, because when you've got a plethora of precedent, i.e. of contracts and of precedent forms and so forth, then generative AI being exposed to that has a much wider universe of things to learn from to create context around the questions that you're asking it. That is going to be a challenge, I think, for the legal industry, because companies like Thomson Reuters, Westlaw, etc., are all generating their own AI, but they're doing that within the expectation that users or subscribers to their products use their generative AI models for their content. The big question is going to be, I think, going forward, is whether these subscriber content providers, i.e. Thomson Reuters and Westlaw, and I'm sure there's more, will be willing to, I'm sure as part of your subscription, expose their content that you're subscribing for to your generative AI models, so that you can create, workflow product for your clients. That is sort of like going back to, well, funnily enough, the initiation of Google and so forth, where Google, is a distributor of content. It's not, at least wasn't a creator of content, but there was certainly a dichotomy change in the relationship between distributor and content provider at the inception, and still to this day, between distributor and content provider, and whether the distributor has to pay the provider for the content and so forth. That is going to be a big challenge in the legal space going forward. I'm running out of time, so I'm going to leave it there. But I think the takeaway from me, or at least my view on AI, is that it undoubtedly is going to be disruptive, but I think that ultimately it is something that we will embrace, and it will largely in the legal space augment human intelligence rather than replace it. Thank you, Michelle.
Thank you, Phil. Very interesting stuff indeed. Can I ask Sam Adair to take over the microphone metaphorically and turn it over to him?
Thanks, Michelle. I'm going to speak about some of the potential ethical implications of using AI as a tool in litigation. And the topics I'm going to cover are, first, I'm going to attempt to get a concept of how lawyers think as opposed to what AI does. Then I'm going to highlight some relevant provisions of the Australian Solicitors' Conduct Rules, which throw up some of the ethical concerns that might arise in relation to AI. And I'll stress that that's not an attempt to cover the field of professional ethics by any means. The third is to hopefully enhance that point by providing some examples, some practical examples from the Civil Procedure Act in particular, about how professional judgment figures into what we do as litigators. And then finally, I'm going to provide a small sample of some of the regulatory responses to the use of AI in legal practice which have come out to date. So we'll just jump into some slides now. Before we dive in, I'd just like to mention that there's a considerable amount of writing on this subject already. But I found an article by Michael Legg and Felicity Bell very useful, and there's a citation of that shown on the slide there. Now, in terms of where we begin, Phil has given us an explanation of AI, and I'll attempt to provide my own gloss on that, which is that we need to understand it's a developing technology. It has not yet evolved into something like a robo-lawyer. And the way Legg and Bell characterise AI is that it's a technology that separates out human prediction and human judgment, but only replaces human prediction. And even then, it only does so under certain conditions. So it's not a computer equivalent of a human brain. I'd suggest then that immediately we can see a key difference in the way that AI operates and the way good lawyers think, the latter of which involves much judgment in quotation marks there. Now, it's very difficult to define the concept of good judgment, but it's widely recognised as being a fundamental feature of competent practice of law, and it's variously described as being more valuable than legal learning or skillful analysis of doctrine, or alternatively, a combination of qualities including knowledge, experience, and understanding of human behaviour. And to quote the words of the former Chief Justice of the Federal Court, the Honourable James Allsop, he described qualities of good judgment as involving integrity, respect, civility, independence, and the recognition of the significance of a dispute to the lives of the humans involved. So on a philosophical level, who we are and what we do as lawyers can't be reduced to an algorithm. So immediately, we have a sign here that if AI is to be used in practice, it can't just be imported wholesale and without any further consideration. I'd now like to give you some examples of our ethical duties which involve the exercise of professional judgment. So moving on to that second point, if we take the solicitor's conduct rules, there's an express reference to judgment in Rule 17.1 of the solicitor's conduct rules, which is the duty of independence. And that rule provides that a solicitor representing a client in a matter that is before the court must not act as the mere mouthpiece of the client or of the instructing solicitor, if any, and must exercise the forensic judgments called for during the case independently after the appropriate consideration of the client's and the instructing solicitor's instructions where applicable. So there's references to judgment there. Rule 17.2 is another instance, and that rule provides a solicitor does not breach the solicitor's duty to the client and will not have failed to give appropriate consideration to the client's or the instructing solicitor's instructions simply by choosing, contrary to those instructions, to exercise the forensic judgments called for during the case as to 1, confine any hearing to those issues which the solicitor believes to be the real issues. And I won't quote further from that rule. But it's notable that both of those rules I've just quoted use the term judgment expressly, and they do so in the context of the duty of independence. The upshot is that both of them require lawyers to make their own decisions about how to run a case. So immediately we can see that, offering an extreme example, it might be difficult for a lawyer to comply with those two duties by effectively delegating their thinking to ChatGPT and asking it to provide a case theory for a 1,000-page brief that might have come in. Now, both of those rules oftentimes will recognise that there is oftentimes no one-size-fits-all answer to a legal problem, and that I think also gives us pause to consider whether AI has the necessary attributes to even do some of the work involved in, for example, choosing between which of a number of competing causes of action might be available on a given set of facts, or prioritising multiple causes of action that might be advanced on a given set of facts. The third example I'll give of a rule that relates to professional judgment is Rule 21.3, and that's the responsible use of privilege. That rule provides a solicitor must not allege any matter of fact in 1, any document settled by the solicitor, and I won't quote the other sub-rules, unless the solicitor believes on reasonable grounds that the factual material already available provides a proper basis to do so. Now, again, the references to decisions and a test of reasonableness point to the notion that we're dealing with judgments made by lawyers concerning matters about which reasonable minds might differ. And each of those rules speaks to the notion of a lawyer forming opinions based on knowledge and experience, and doing so, hopefully, with honesty and integrity. So at least on an ethical level, it's not easy to envisage a lawyer acting appropriate were they to simply delegate the thinking to an AI algorithm. Now, moving on to my next stage, I want to move to a more practical level and get a small glimpse of how professional judgment features in civil case management. The obvious contenders are the overarching obligations in the Civil Procedure Act and the Federal Court Act. The Civil Procedure Act, Section 56, we'll all be no doubt familiar with, but that actually imposes duties on both litigants and their lawyers. And subsection 4A provides that lawyers must not cause clients to breach their duty of facilitating the just, quick, and cheap resolution of the real issues. Now, the ability to identify the quote-unquote real issues in a case is a quintessential matter of judgment and comes from the benefit of lengthy and sometimes bitter experience. Another area calling for judgment is in relation to lawyers' duties to take proper account of the proportionality of costs in a matter, and that's found in Section 60 of the Civil Procedure Act. Simply put, the idea is that the costs incurred in relation to a particular issue should not be all out of proportion to the relative importance of that issue. And Josh is going to say a little bit about costs when he speaks, so I won't say too much more about that. And a third example I'll give, and it's a particularly stark one, an instance of courts relying on lawyers to exercise judgments in relation to the approval of settlements of claims by people under legal incapacity. In those cases, courts explicitly rely on lawyers' opinions about matters including whether a settlement is in a claimant's best interests. Now, that sort of value judgment, I would submit, cannot be reduced to a mere probabilistic calculation based on data analysis. It's a human decision, essentially. The fourth point is, and my final topic, is just to note that there has been some engagement by professional regulators with AI issues, and I would suggest that the publications we've seen to date tend to show a concern that lawyers should not use AI technology in such a way as to compromise or effectively abandon their professional judgment. The first publication I'll mention is the New South Wales Bar's 2023 guideline document, and that's called Issues Arising from the Use of AI Language Models, including ChatGPT in Legal Practice. That document goes through relevant parts of the barristers' rules and comments on potential implications that using AI could have in terms of compliance. Now, the first order of business is Rule 4 of the Bar Rules, which is an analogue of Rule 17.1 of the Solicitors' Conduct Rules I've taken you to. And the guideline given for those intending to use AI states that barristers, who could read lawyers, should only release work under their name to a client or a decision-making body in relation to which they, 1, have exercised independent forensic judgment, 2, have advised independently, 3, have reviewed and edited where necessary, and 4, believe is correct and reliable based on their training and experience. So the message there is that it simply won't do to hand up a ChatGPT product in court or conference without careful consideration before doing so, at a minimum. The Bar guidelines also say, at pages 3 and going over to 4, that transparency is important, and that includes in relation to costs implications of using AI. And the guideline says, to the extent that AI is able to be utilised as a labour-saving tool to reduce the amount of time required for a particular task, if using a time-based retainer model, that is, the amount of time charged to the client must obviously reflect the amount of time actually spent on the task. The VAR guidelines also provide us with a cautionary tale, and they cite a recent US case called Marta and Avianca as an instance highlighting potential risks associated with the use of ChatGPT in particular. And the guidelines describe that case as an instance where a New York attorney filed a submission based on research using ChatGPT, which contained case references that were entirely false, and that matter was revealed when the opponent and the judge attempted to access the cases cited and found they did not exist. Now, those lawyers who did so and didn't promptly own up to their mistake were subject to disciplinary action by the court. And Josh is going to speak about that case in a little more detail, so I won't take it any further, save to acknowledge that Marta and Avianca is apparently the leading authority on what not to do with ChatGPT. That's not to say that AI can never be used in practice, and as Phil has pointed out, it's already in use in some litigation firms, it seems successfully, in relation to tasks such as document analysis, discovery or review of clinical records. Hopefully, without trespassing too much on Josh's topics, I'll just note that some lessons learned from Marta and Avianca have been outlined in a paper issued recently by the US Association of Corporate Counsel. And the pointers given there were that lawyers intending to use AI need to first understand the technology, and I interpolate that would include reading the fine print about how a client's information is to be used by a product if we're intending to feed it into the AI. Second, identify appropriate tasks for the use of AI. And third, be transparent and correct any mistakes that happen immediately. We really come back to the same point, which is that professional judgment is critical to what we do as lawyers, and we will end up in trouble if we simply delegate that function to a machine. That's all I have to say, so I'll hand over to Josh now.
Thanks, Sam. I won't say a lot more about the case of Avianca and Marta, but it is an interesting one. I'm sure a lot of people have seen it in the press. The algorithm or ChatGPT in that case actually went so far as to provide a whole load of bogus quotes in those cases, which is quite interesting. I understand the attorney basically ripped off those quotes and copy and pasted them into his written submissions, and he was disciplined. I think he was given a reprimand of $5,000 or something like that. So it does interest me that people talk about that case of Avianca as if it's quite an exceptional one, as if the ChatGPT is usually pretty robust and watertight, and there are these few anomalies where things go wrong. The reason that interests me is it's certainly not my experience with using ChatGPT, and I think that the platform as a whole has a lot of flaws and is really, really dangerous when it's used without careful consideration. Cases like Avianca probably occur every single day, even though they don't hit the press. So I thought it'd be useful to kind of demonstrate the point by running through a little experiment that I ran on ChatGPT the other day. Is anyone here who hasn't used ChatGPT? Maybe a raise of hands would be useful. I can't see a lot on my screen. I'm sure there are. I'm sure some people use it, some haven't. I don't have a lot of experience with it, so it was an interesting exercise for me to go through. So I opened the app. I started with a pretty rudimentary question, which was, what are the elements of the tort of negligence in New South Wales? The response I received was largely correct. Went through duty, breach and causation, were all summarised. There wasn't any reference to the Civil Liability Act, but I thought that was excusable in the circumstances. It also listed foreseeability as a separate element, so duty, breach, causation and foreseeability, which is not strictly correct, but again, it wasn't a major issue, I didn't think. The second question I asked it was, what is an apportionable claim in New South Wales? Again, the response was largely correct. There was a reference to the Civil Liability Act, not Part 4 specifically, but again, I thought that was okay. The third question I asked was, when is a claim non-apportionable? And I got some correct examples of non-apportionable claims. The next question I asked was, what are the facts of Ballas and Theophilus, which is a 1957 High Court case? And the reason I asked this was I wanted to identify whether ChatGPT assumed there to be some correlation between my previous questions and the facts of Ballas and Theophilus. I thought it'd be useful to read out the response I received. ChatGPT said this verbatim. The plaintiff, Ballas, was driving his car along a road at night. The defendant, Theophilus, was also driving his car in the same direction. Theophilus signalled his intention to turn left. Theophilus slowed down and began to make the left turn. The plaintiff travelling behind Theophilus did not notice Theophilus's turn signal. The plaintiff's car collided with the rear of Theophilus's car. The plaintiff claimed damages, etc. So Ballas is in fact a decision about a partnership dispute between two parties, and it stands for a particular proposition about implied terms in contracts. So clearly, absolutely no relationship to the facts that were spat out by ChatGPT. So I gave ChatGPT a second chance. I figured that what had probably occurred was that ChatGPT assumed that there was some correlation between what I had asked and the case of Ballas and Theophilus. So this time I started a new thread, I'll call it, in ChatGPT. I'm sure there's a technical name for it, but in effect, I started a new window, so to speak, so that there was no reference to the previous questions I'd asked ChatGPT. So I asked the same question. I said, what are the facts in Ballas and Theophilus? This time I was told that Ballas is a High Court case concerning promissory estoppel, and the facts seem to resemble Wolfen, Stalls and Marr. I then asked ChatGPT, what case have you summarised above? And it fessed up, said, the case I summarised was not Ballas and Theophilus. Instead, I provided information about a different legal scenario. So self-evidently, ChatGPT is far from perfect. If I hadn't prompted it to correct its answer, I'm sure it wouldn't have done so. It would have had no issues with me copy and pasting that response and putting it into a set of submissions, as our US attorney did. So there are clearly issues with using it as a resource for legal research. One of the other issues is that ChatGPT 3.5, which I believe is the free version, has only been trained on internet data up to September 2021. So you're not going to get any fresh information or cases or legislation. In my view, I personally don't see any value in using ChatGPT that can't be achieved by using a legal database. I do accept that the results in ChatGPT will often come faster than you'll receive in a legal database, but I think this efficiency is probably outweighed by the need to carefully check each and every answer. So to me, it begs the question what role it currently has to play. I'm sure it will develop in time and improve its usefulness. Another interesting observation of mine is that when ChatGPT does provide an accurate response, my experience is that this is usually because there is so much commentary on a particular issue that it's kind of difficult for it to get it wrong. So, for example, the question, what are the elements of negligence in New South Wales? There's so much commentary on such an issue that it's difficult for it to get sidetracked. And that begs the question as to why the platform is necessary in such a circumstance when one could simply Google the question and receive a similar response, or open a textbook at chapter 1 of the Law of Torts. So there's absolutely no doubt that many lawyers in the market are using ChatGPT, so I'm sure there is some value to be gained from it. I have on good authority that a big law firm in town provides a kind of hotline service to their clients, and the lawyers in this team are transparent with their clients about generating the advice through ChatGPT, because it's a hotline service. The answers are generated pretty quickly, and they're quite transparent with their clients, and they say, look, we haven't had time to confirm this, but ChatGPT tells us X, Y, and Z, which I think is quite an interesting use of it. So the final kind of issue I want to briefly touch on is the billable hour. Some of you will know of Nielsen DCJ in the district court, who starts each of his judgments on costs with the following observation, and I quote, "Nothing excites the zeal, the ardour, and the passion of members of the legal profession more than an argument about costs." There's obviously no escaping the reality of His Honour's observation there. So in my view, the manner of charging clients in circumstances where one uses OpenAI, such as GPT, shouldn't be any different than using any other platform to achieve efficiencies. I think, as Sam said earlier, the Bar Association has released a guideline on the use of OpenAI, and it says, to the extent AI can be used as a labour-saving tool, the amount of time charged must reflect the amount of time actually spent on the task, which is probably self-evident to most lawyers. The billable hour is not a very good metric to deal with efficiencies achieved by using resources such as AI. And that's simply because the billable hour doesn't discriminate between efficient work, non-efficient work, important work, or non-important work. In my view, the efficiencies created by using AI can be likened to many other resources. When one generates a contract through a template and a precedent, or works out a legal answer based on a database or a textbook, one achieves an efficiency, but the billable hour has no way of accommodating that efficiency. And that's, in my view, just the simple reality of the way that most of our billing models with clients work. Another obvious example is discovery software that provides the ability to exclude millions of documents that otherwise might have to be reviewed by a paralegal or a lawyer. So in those circumstances, there's no ability to recover the costs of the time that's been saved by using such software. So, I mean, the flip side, of course, is that as technology advances, technology has also generated a lot of work for lawyers. So that's probably the silver lining. But yeah, in my view, that based on the current way that we bill clients, I think AI should be treated as any other efficiency saving means. So that's all I wanted to say.
Thank you very much. I'd like to open it up for some questions. We've got a few minutes before you all have to get back to your own billable hours. I don't know if we have a way for you to indicate you want to ask a question. So let me just get a gallery screen. If you do, turn on your camera and jump up and down, and hopefully someone will see you. Speak up. Otherwise, no takers. Okay, well, look, if you think of something in the meantime, feel free.
I've got a question.
Oh, good, sorry. Good, I'm glad I caught you. Please go ahead.
So, I mean, at the moment, AI, like ChatGPT, is separate platform. It's distinct from legal research databases like LexisNexis. I would have thought the way forward for the use of AI, or one of the ways forward, and we did in the discussion talk about how AI could be used as part of discovery. But one possible way forward for use of AI in the legal industry would be for some sort of partnership arrangement between AI like ChatGPT and then legal research databases and platforms like LexisNexis. So instead of going into LexisNexis and using the advanced search function and typing in the name of the legislation and trying to do keyword searches, you could just go into LexisNexis. It's got ChatGPT functionality in it, and ask it questions, and do your legal research via a thread in that way. What are your thoughts on whether that's a possibility, or the practicality of that, or whether you see that as being something which may happen?
Sam and Josh, do you want to have a go at that, or do you want to turn that over to Phil?
I think Josh had a.
I was actually going to hand it over to Phil. I was going to say that Phil spoke earlier about the.
Yeah, sure. I mean, I think I touched on it briefly in my presentation. To me, there's no doubt that content is extremely valuable to the generative AI model, because it needs to be exposed. I mean, they're large, essentially large learning modules and self-learning. So the more you give it, I guess to Josh's point around negligence, the more accurate it becomes. The problem, and this is the Google versus News Corp type problem, from Google search sort of issues, is content providers don't want to give away their content for free, and they certainly want to maximize the value they get for their content. So, for example, LexisNexis presently are developing their own AI model, but it's only for use within their own little, well, not so little, but their own world. As a barrister, and I'm sure plenty of lawyers out there would love to have their version of ChatGPT or whatever the proprietary in-house models they've got, be able to interrogate the extensive legal database that Thomson Reuters or LexisNexis provide. The question is just going to be about price. Who's paying and how are you paying? And so answer to your question is undoubtedly in the future that'll happen. But there's a competitive or commercial arrangement that needs to be sorted out between the respective AI provider and the content providers. Look, and I said in my speech as well, undoubtedly the bigger law firms, because they've got so much of their precedents already, their capacity to expose their AI versions, whether it's Harvey or ChatGPT or whatever, to an already existing large database, gives them a comparative advantage versus the smaller players.
Thanks, Phil. Does anyone else have another question? No, I can't see anyone. All right. If you think of anything, like I said, feel free to email any of the speakers or our clerk. Hang on, something's come up. From Ben to everyone, there's a newly described phenomenon called AI drift, where the AI is getting dumber. Well, that's worrying. What's the liability for the big law firms using it now? Does anyone want to have a quick stab at that?
Sorry, I don't want to monopolise, but let me quickly answer what I think. I mean, my observations is I agree with you. I don't know if it's getting dumber. Maybe the users that are using it are dumber and it's learning from dumber people. But the second point of it is certainly in the legal space, you start asking legal questions, the generative AI models, in particular ChatGPT, seem to be stepping back from answering those a lot more, and there's a lot more disclaimers and so forth that are going with them.
Okay, terrific. Well, I'd like to thank everyone for joining us. These are an occasional series that the floor runs. We're always happy to receive suggestions about what our next set of topics might be. We have a range of different types of experience and expertise amongst all the barristers of the floor. So if you've got something coming up and you'd like some sort of high-level discussion about the general topic, again, email our clerk, email any of us directly. Thank you for coming, and we hope to see you again on the next occasion. Bye, everyone.